So welcome to this March 2023 probate paper that was done, and the results were released in June, and this was the second most failed paper after conveyancing, and I thought it was worth we look at it before the exam start. This is our last paper for preparation for exams. Probate, as we have said in our last class, that for you to pass probate, you need to know to understand the Law of Succession Act, and we also need to know the probate rules. You know how to have to draft, and also to know have some case law, and two very important books you need to know to have is the Law of Succession book, the yellow one by Musioka, and the Procedure in Law. Procedure in Law of Succession by Mary Angawa, a judge, a former judge, the revised one. So with those documents, we are you are armed. So I'm going to read the question. Question one. Blessings. Married Carrington under Civil Marriage Act 1970. Their marriage were blessed with the two issues, James and Mary, and Mary born in 1971 and 1973 respectively. Blessings was a nurse. Carrington was a consultant pediatrician. Dr. Carrington is a consultant at Kenya National Hospital as a government employee, and at the same time operates a private clinic. Blessings and Carrington were a hard-working couple. They made efforts to purchase properties registered as joint tenant. That's very important, and tenant in common. Other properties registered jointly were Nakuru, Ngata Block 12, Nakuru Municipality Block 15X, Nairobi Karen Block 2DD, and Mombasa Municipality Block 34106. Mombasa, Nyari Block 22 is owned by Mary and Carrington. So that is also very important. Carrington owns owned and Mary tenants in common. They own a property with her daughter. Properties acquired registered by Carrington alone were Nairobi Karen Block 2103G, Kisumu Milimani Block 24107, Kisimani Municipality Block 110/708, and Mohorini Adra Block 15Z, Sham Level Apartments in Aviton, and 2 high-range motor vehicles. Carrington and his doctor colleague Joel purchased land which they developed and set up a business premises, which is they named Jay-Z Doctor's Plaza. Jay-Z Doctor Plaza was jointly owned by Carrington and Joel. Another very important information. In the year 2000, Carrington was concerned that he had too much property and few children, and was advised by his father to marry another wife to bear more children for him. Unknown to Blessings, a traditional wedding was organized. So the first wife did not know the traditional wedding was organized. Carrington married Joan in 2001. In January 2000, Blessings learned about the existence of marriage when he stumbled upon the birth certificate in the house bearing the name of a child named after his father-in-law Peterson. When she confronted Carrington, he opened up and told her they had married Joan and that Peterson was his firstborn. The discovery upset Blessings. creating a fertile ground for discontent and frictions in the marriage. Carrington built a palatial home in Kivu where he moved and stayed with Joanne. He would make occasional visits to Blessings. When Joan got her third child, Duke, in 2004, Blessings could not take anymore and decided to file divorce in 2005. The marriage was divorced in 2008. In 2010, Blessings sought for division of matrimonial property. The parties entered into a mutual agreement to divide the properties between themselves except for those owned jointly with others and or solely by Carrington. In the division of properties, the following were given to Blessings: Nairobi Karen Block 12YY, Nakuru Gata 12HH, Nakuru Block 15X, Nairobi Karen Block 2D, and Y High-Rise Motor Vehicle. The rest of the properties were given Carrington except that which were registered as tenants in common. On 16 January 2011, the court ordered Carrington to execute the relevant conveyancing to facilitate the transfer of respective properties. In 17 January 2011, Carrington was involved in a crash in Mara, in a plane crash. That is now 2011, and died on the spot. At time of Carrington's death, all Joan's children, Peterson, Wendy, Duke, were all died. Joan had resigned from the job to marry Carrington, and he had told her that he would pay her mother to take home and take care of their young children. Mary is mentally unstable. That is also very, very important. And Joan's children are died. Are with his mother, Blessings. James had married, James is the first child of the first wife, Blessings, living in Germany with his wife. The family met after burial to discuss the distribution of estate of Carrington. Joan is unhappy and is adamant that her children are young, and if there is anything to be distributed, she must have a great share of property owned by her husband, Joan. Joan was of the view that her children should have priority of other children since they was official wife of Carrington. She considered marriage as an invalid and necessary of deserving inheritance, and that Mary is already provided by virtue of Anish of Mombasa Nyari Block 2/2AA. That Blessings have been divorced is not a and therefore not a beneficiary on of the estate. An expert in probate. So question one usually have a lot of things, the compulsory question, and it's always good to take time to read and underline the most important facts that you are going to use to help you answer the question. Using the relevant legal provision and case law, explain what is the fate of JC Doctors Plaza would be. What do you think, Marianne?
So I think the property at Doctors Plaza was property yes, the property at Doctors Plaza is property that is jointly owned. So, and if it's property under joint tenancy, then under Section 2 of the Land Act, it's land that has undivided interest. Okay. So this land usually devolves through the doctrine of survivorship to the other joint tenants. Under Section 43 of the Land of Succession Act, Law of Succession Act. Yeah, and the case I would rely on to back this is Mwangi Gakuri versus Bernard Minor. Okay. Yes.
Sawa. So it will go directly to Joel, to Nini. Yes, it will go directly to Joel. See, that's how you conclude. Because Joel was the one who they bought with Carrington. Sindio?
Yes, Mwalimu.
Yeah, so, yes, what is the difference between, okay, what is the joint tenant and tenant in common? What is the, now, what is tenant in common?
So tenant in common is where you have you're owning land in common, but then you have separate shares. Like everyone knows their specific share to this property. Okay. So this property does not devolve through survivorship. Instead, it goes to the estate of the deceased, their share for devolvement up to his beneficiaries.
Yes. So that is the difference between survivorship. Anytime you are asked about joint tenant and tenant in common, that is the difference. Joint tenancy, upon the law of succession is not followed, the property devolves to the other tenant. So under Section 60, I think, of Land Legislation Act, upon death of the other tenant, you take the death certificate, and the registrar deletes the name of the deceased and adds you as the person who owns the property. Under that. So this is a question that is repeated many times in the past. It is there in the Q&A. Latest was in April, question 1, see April 2022. And I think if you see a question that is repeated directly, from, okay, this was not a direct, it was in April. So this is a question usually that usually comes a lot, and it is very, very important someone understand that doctrine of survivorship. So because of time, I'll go to the next question. Advise blessings on her rights of inheritance from the estate, if any. Miriam?
So blessings, first of all, blessings is a former wife. Having been judicially separated from the husband Carrington.
Divorced.
So yes.
They divorced.
They divorced, and they were entering into a mutual agreement for division of matrimonial property.
Yes.
Except for the property that was jointly owned with other parties, with Carrington.
Yes.
So, first of all, blessings is, first of all, if because of the division of matrimonial property, she got her share, but the share that she has not yet received through the division, blessings can become a creditor to the estate of Carrington. But the second part is she's also entitled to a share in the common property because of the doctrine of the ones that they had in common, because of the doctrine of, is it? I'm forgetting. Oh yeah, because of the doctrine of joint tenancy and survivorship. There are those properties that they had in common that were not separated. And I think still under Section 29 of, although we say that this divorce had been finalized, so I'm not sure we can call her dependent again under Section 29A.
Yes, so this question is 4 marks, eh? This is how you are supposed to answer it.
Yes.
A divorced wife who has gotten a settlement
Yes.
is not okay. There are two scenarios which can come in an exam because you are not limited to this question. A divorced wife who has not gotten when the proceedings are still going on in court is still a dependent. But after the divorce is done and they have been division of matrimonial, as in this case, the wife cannot get anything from the estate because the matter has already been settled and he has already gotten the settlement. Are we together?
Yes.
That is the answer. Of course, can a divorced wife be petition? Can a divorced wife petition for grant?
I think she can if in the specific instance where she has underage children. So when she's doing it in the interest of her children, or if she's doing it as a yes.
I'm talking about blessings.
Okay, in this situation, okay, yes, still she can do it on behalf of Mary, the child, the daughter with disability, as her next friend.
But you see,
yes,
under section 66, you know, these are the questions that usually come under section 66. A divorced wife, a divorced wife is not a spouse.
Okay, I'm saying she can't do it for her own basis, but now she has made the child with disability. So I don't, which section is that? There's a section that provides for, I feel like we can do it under the same section that provides for like underage children, the way their parents can petition for them on their own behalf. Since Mary herself, but that's only if Joanne refuses to take out grant.
Yes,
or
but
denounces her.
Yes, but Joanne is there. The only thing that can come here is he can make an application for Mary, but Mary, of course. Anyway, let's not go ahead because this question is already asked here. Is a question that is asked here. Question C. Advise Joanne on how to is the D. Advise Joanne on how to safeguard her rights in the estate. Okay, let's first of all look at how the best performing student answered this question. It's also very, very important we compare. That is question 1. Question 1, she got 13 marks. Of course, joint survivorship. You have stated there the case. That's not a big problem. Section 29 provides that the dependent do not have to include the wife, former wife, or deceased. Blessing is a former wife of the deceased whose marriage was divorced in 2008. Subsequently, in 2009, she saw the division of matrimonial party. The parties entered to agreement to divide the properties between themselves, except those who are jointly owned with other parties. Subject to the agreement, Blessing got her share of the property pursuant to the property that was jointly owned. Therefore, she will only be entitled to her share in common property given that she is a divorcee and the divorce of the property has already taken place, subject to 2010 application of division of matrimonial property. So that is the law. The only property you get is property that is jointly owned with Carrington. But as far as being a dependent, a divorced wife who has already gotten a settlement in the divorce court, division of mortal matters cannot become a dependent. And this question is repeated in question 6 July 2019. What if he did not had gotten is a divorced wife and thinking also that let's first of all remove Mary. He does not have a child who is depending on him, and he has not been given anything in the estate. And there is another wife who was married later has petitioned. What do you think would be her recourse? That's a question that can come in an exam.
Well, I feel like Mary would now become a creditor of the estate because there's property owed to her, the joint property that was not divided before. Yes, but in that case, yeah, she'd only come as a creditor, and that would be in the situation where the family, who in this case is James, the son, has refused to take out grants and denounced his right. Yes. So she would have to cite him first to take out grants. If he still refuses, then she'd have to do it now as a creditor of the estate to get the property due to her.
Okay. Sawa, that is correct. So I think we can go to the next question. Because of time, advise Joan how to safeguard her rights in the estate, even and those of her children. Marianne?
So Joanne should assert her position as the wife of Carrington. The law of succession recognizes her as a wife, as does the Marriage Act. They had a customary marriage, and that her children with Carrington are his beloved.
Stop there.
Yes.
Stop there first.
Yes.
I want to ask you a question. Carrington married as a civil marriage in 1970. What kind of a marriage was that? Was it monogamous or monogamous?
Monogamous.
Did he have capacity to marry another wife?
Well, he did not have capacity to marry another wife as per the Marriage Act, but Section 3.5 recognizes Joanne as a wife nonetheless.
But that's what I wanted you to bring out. Yes.
Okay.
Continue.
So the law of succession under Section 3.5 recognizes Joanne as a wife for purposes of succession. Joanne's children are also recognized under Section 3 as children, the biological children of Carrington. As such, they are automatic or beneficial heirs. Section 3.2. So I would advise Joanne to petition for grants. Yes. For letters of administration intestate.
Yes. Yeah, that is the correct answer.
You can also, I can also add that because her children are also underage, she should also look into establishing continuing trust under Section 41 to safeguard the interest of her children.
Yeah, which means you have add another administrator.
Yes.
Yes. So you know why I wanted you to bring up to the issue of Yes, section 3.5 is very, very important. Every time you, because this question usually comes a lot. And section 3.5 also means that a wife for that purposes is also dependent, can also make a dependency. It should also be provided a spouse, a wife. Because if you look at section 3.5, it usually says that he has the right not only to petition for grant of representation, he can also make an application for dependent as a dependent. So it can come in an exam with two scenarios. Whether the second wife, despite the existence of an monogamous marriage, is a wife, and so that he can petition for grant under section 66. And also he can make an application for as a dependency under section 29. Yes. And also is recognized under section 40, which talks about polygamous marriage. When the estate dies monogamous, so the estate is distributed as units. So all those scenarios can come in an exam. So it's very, very important to bring out section 3.5. Yeah, so that is the best performing student say that. I don't think there is anything to add. You need a case law. Do you have a case law there?
For women considered wives under section 3.5.
Yes. Who petitioned and got a grant of representation?
I don't have one, because the ones I'm thinking of, I think all failed, like Ruben Zioka. So I don't have one. So if you could share one with me, I would be happy.
It say there's this student is saying Kitwaja, the court said the customary marriage one proof existence. No, he was talking about Kitwaja versus Kitwaja. Marriage, civil marriage, 19 first part of the student. Question 2B. April 2022 2B. Let me see if it has a case law. It is very, very important for any question, because this question usually come to have a case law. Let it open. You can open in your Q&A if you are able to, April 2022. Anyway, we can continue because it's taking a lot of time to open. You can look at question 2B, April 2022. I think it has a case. You need a case on that. Let's go to the next question. That is question D. Profile a legal opinion on the possession of Mary as a beneficiary. What do you think?
So Mary is an heir. She is the child of Carrington under Section 3(2) of the Law of Succession Act. Mary is also entitled to the property in Nyali as a tenant in common, because they have separate shares between her and the father. And the courts can put it into consideration when awarding her share, but Mary is still entitled to a share from the estate of her father, Carrington.
Okay. Yes. Then can a person of unsound mind hold a property?
Yes, they can. It can just be held in trust by a next friend, like her mother, in this case, Mary. Blessings. But yes, an adult of unsound mind can own and hold property. No, nothing prohibits them from doing so.
Okay. Yeah, I think you also needed to add that, because it's mentally unstable and live with her mother. It's also good to add that. That answer is not complete if you have not said that. The best performing student answer. Mary is a child, of course, 29A. Mary Cons property, Mombasa, so that goes to her. Section 40 provides for when a person died polygamous, the other properties that are not owned jointly, of course, the rules of polygamous come in. So where the mother and the children in each house become units, and that the property will go to them. Have you said that?
No, but I'm wondering, in this case, should we have applied Section 40 since he's divorced, or even just having a former wife makes you a polygamous?
No, he's not a spouse. He has already gotten the nini, but you see the children is the other house. James and his wife is one unit and Mary is another unit outside her mother.
Okay.
Yeah, that's what I mean. So it was also very, very important to say that. Are you together?
Yes, we are.
And you get a case where property was divided in a polygamous situation. There are very many cases. Find one.
Yeah.
I can bet for you 100%. A case. There are things I usually know they will come. They usually come in every probate. For example, a polygamous marriage, that one must come. It must come. That one. So you need a case law where property was shared in a polygamous way. Another very, very common question is where children in an adulterous union. So those ones usually come every exam. So you also need a case law. And the famous case law is Mobea versus Mobea. And you can add another one, others. And of course, you quote the law. Are we together?
We are together.
Divorced wife, it's rare, it has not come, but it was not the first time it came. It had been repeated. So we go to the next question. Question 2. Mr. Abia has one wife, Alice, who bore 4 children. He also had a son, Abednego, whom we got with a lady in a secret relationship with Ms. Abisai had. So you see now what I'm saying. Children in another trust union. Those questions are very common. Abednego, who got with a lady he had in a secret relationship with Ms. Abisai, had in place will, wherein he bequeathed everything to Alice and for 4 children. Back in his mind, he knew he would later amend his will to include his son Abednego. However, it did not happen as he did abruptly following a tragic road accident. After his burial, Alice, armed with a will, sought the services of a lawyer. One of the witnesses to the will, who was close friend of Mr. Abisai, informed Abednego about the will and even gave him a copy. Abednego, who was second-year university student, was distraught that he has left out of the father's will and decided to take legal action. He subsequently visited the Pro Bono Lawyers Association, where you are employed as legal counsel. His matter has been allocated to you for your action. Explain what type of application you would institute on his behalf. Miriam?
It's an application for reasonable provision.
Yes. Students usually make a mistake of saying that a child in an antitrust union can go and revoke a will, a grant, or post a grant to be given. No, you cannot do that. The only thing you can do is an application for reasonable provision. How do you do it?
It's done by petitions, by petitioning the court if it's before the grant has been applied for, or summons if the grant has been applied for.
Yes. How would you prove? How would you prove that you are the son of the deceased?
Section 3(2) recognizes children, illegitimate children, as children of the deceased, so long as, in this case, he was a biological child of the deceased. Although there's a case that removed the burden of proving under Article 53 and 27 for discrimination, they removed that burden of proving that you're the biological child. Can't remember, but I know Madam Anastasia had discussed it. But yes.
Okay.
So, yes.
It has not been removed. The correct rule now, the courts are moving towards DNA testing.
Okay.
The DNA testing is the new practice that is being done by court for you to prove that you are, if there is dispute at the parental, if you say that you are the child of the deceased, and you need a case on that, I think where DNA was used to prove that DNA is usually, that is the order of the day in row of successions, that the DNA is ordered to the child who is being disputed, because the other family will say that it's not the child. So DNA is taken from this family and the person who has come to court. And there is a case law, I think, in the Q&A. And if there is no Q&A, if you don't find a case law in Q&A, you can go look online. There are very many these days. So it's good to have a case law because of the exams. It can come that way, where DNA is being used to prove that you are the biological child of the deceased. Are we together?
Yes, we are.
With help of case law and relevant statutory provision, discuss 4 circumstances that court would consider when ruling on application of this nature.
So the considerations of the court are provided for under Section 28 of the Law of Succession Act, and include the current and future needs of the dependents, the circumstances of the other dependents, the nature, scope, and size of the estate of the deceased, the current and future income of the dependents, any property the dependent had been given in the lifetime of the deceased, under the doctrine of hopscotch. And then there is the relationship between the dependent towards the deceased in life. And then there is if the deceased had reasons to leave the dependent out of the will.
Where, for example, the deceased are not in good terms with the person and is left after of the will. Would court give the reasonable provisions with to the person, especially, for example, if he disrespected the father, he was cast? That's a question that can come that way. What do you think?
I feel like it has to be a justifiable reason, and the court would consider it with keeping in mind the other circumstances as well. But if the court finds the reason sufficient, then it will not provide adequate reasonable provision for him. But it has to be like a sufficient reason. Like there's the case we cover it under suspicious circumstances, but there's a case where the son sued because the solicitor got a quarter of the will, but it was later found out that the reason the father had not put him in the will was because of his criminal conduct. So like that was seen as a sufficient reason.
Yes. You know, under those grounds that you have stated there, you know, you need to have a case law. You need to have a case law. I'm now projecting the answer given by the best performing student. Of course, Section 28, any existing and future needs of the dependent. The court considers the past, future, and present needs of the root. The court in real estate, Muigai Njaramba, consider the needs of the dependent who was left out of the will. The court considered the fact that he was still a student studying at Musorongori Secondary, and therefore he was indeed in need of process of the estate. In the present case, the court will take it. So this is one of the cases in the estate of Muigai Njaramba. You can look at it. The behavior of the defendant towards the deceased. And here he discussed John Kariuki Kidongo versus Matthew Kariuki Kidongo. The court considered that John was living abroad and he was not in constant communication with the deceased. Further, he did not attend the burial of the deceased, and he had only come back to the country to request the share of the property. The court found that the deceased reason for not living out the son was justified. So these are cases you need to look at: John Kariuki Kidongo versus Matthew Kariuki Kidongo. I like this student, the way he has case law. Any property gives advance to the defendant during deceased lifetime. And he discussed the case of estate Baki Otieno. The court considered that the deceased has left 2 cars to the son during his lifetime. Therefore, it could not take into consideration when providing for reasonable. He was already given. You need a case law there. Any present and future income of the dependent, for example, students who are in school, minor students, minor children. So I think you need a case law under each and every ground if it comes in an exam. Are we together?
Yes, we are together.
Yeah, you can look at the answer of this best performing student and other case law. You make a good answer. In fact, it can come as a it can come as a question on its own, 10 marks. It tells you to discuss section 28. 28. So it is very, very important you have case law under each and every ground. And the case law are there. So we go to the next question. The next question is, I'm going to read it. Jury wrote a will in 2006, leaving all his estate to her siblings, Paris and Jenny. Question 2B, there is another question 5 November 2019 was on the same thing on reasonable provision. So you can also look at it. So I got to question 3A. Julie wrote a will in 2006, leaving all her estate to her siblings, Beris and Jenny. Should she precede the death? In death, due to Julie's health condition, Paris was entrusted to take care of her. Her condition required someone to be around her to assist her in movement and daily care. Julie's demands often left Paris exhausted, and so he would forget to attend some of the calls in the house. This irritated Julie and made her to revisit the will to remove Paris from it. In one of the days, Julie grabbed her will from her bedside drawer with the intention to revoke it. Patrick and Curry, her nephews, had visited her that day and were in the bedroom where she intimated to them she wanted to revoke her will and would need their assistance. She handed the will to them who burnt it within her compound. 3 days later, Julie died as an issue and arose as to the will she had written. Using relevant legal provision and case law, discuss the validities of Julie's action. Marianne?
So the law of succession under section 18 and 19 provides for the revocation of a will. In this case, specifically, it refers to voluntary or express revocation of the will. And for you to have been seen as actually destroyed a will, you must fulfill the requirements under Cheese versus Lovejoy, which is one, you must actually do the actual destruction of the will. And two, you must have the intention to burn the will. You must also have the capacity to destroy the will, as seen as Rianne's leave. And then the destruction must be done either by the testator or in the presence of the testator, as was seen in Jill versus Jill. So in this case, Julie had the intention to destroy the will, and there was actual destruction of the will in the form of burning of the will within the compound. However, the destruction was not done in the presence of Julie. So this destruction was not valid. As such, Julie's property will devolve into through the laws of intestacy. Yes.
Okay. You are saying there is somewhere you are saying the actual destruction was not made in presence of Julie. Then continue.
The actual destruction was not made in the presence of Julie. This was held in the case of Jill versus Jill. So the destruction was invalid. As such, her estate, the estate of Julie, will devolve through the laws of intestacy.
If the will is valid, you say?
Oh, the destruction is not valid. Okay, yes, it will devolve through the will.
You see, you see, there is contradiction there. I think what you are saying, because the will is already burnt and it's completed, and of course, you know, under the law, it must be in his presence. But I would say, provided he had the intention and he gave it to the nephew and it was destroyed in the compound, Although, you know, it can be looking at from the window. Unaona? It can be looking through the window.
No.
Yes, sorry?
Yes.
So
I'm agreeing.
So because it was destroyed completely, the rules of intestacy will apply. But you cannot say the will was not validly provoked, so that is valid that it cannot be seen, it has been burnt, then you say intestacy. Can you see there is a contradiction there?
Yes.
So you must say very clear that the will was burnt completely, and so that the intestacy rules applies. And this question for a will which was burnt has not been tested again. The other question that we dealt with 5B October 2022 was on tearing, but they joined the pieces again. But burning, where testator burnt the will, or he told someone else to burn on his or her behalf, has never been tested. And one needs a case law there. Of course, an English case law where a will was burnt and it was found to have been invalid. So you get an English case law if you get time, eh?
Yes.
In Kenya, such kind of scenario is very hard for them to happen. So these are English case law. We go to the next question. That is question B. By will, Diana bequeathed all her estate to Paul, her only surviving relative, and lost her best neighbor. She had a copy of the will in bedside drawer and one kept at her attorney. Caleb. Diana and Rose had issued and constrained their relationship over the years. Diana decided to make changes to the will and deleted Rose's name from the will. She then took out the will and cancelled Rose's name using the red pen, signaling his dislike for her. Diana appended her signature, date, and deleted section of the will. Diana died in her will and was found in the bedroom in the direction. Paul is happy that all now remains her sole heir of Diana. Paul has gone to inform Caleb of the changes Diana made to the assist he will be given the properties left by Diana to the exclusion of Rose. He also informs Rose that Diana had removed her as the beneficiary under the will. Rose has sought help from you. Advise her on the legal rights, if any. Vivian?
So the law of succession provides for alterations to wills under section 17 and 20. It provides that if it's done before the execution of the will, that it should be final and not just deliberate alterations. And then if it's done after, it will be invalid unless it was properly executed per section 20, which includes it has to be signed, witnessed, and attested, like for the will. So in this case, the alteration was done by Diana to remove Rose from the will by cancelling, I think, her name out of the will, and then she signed it. But unfortunately, this was not attested by two independent and competent witnesses. So the alteration is therefore invalid, and Rose can still claim as a beneficiary under the will.
Very good. So that is very good analysis. You did a case law there, also an English case law. I want to read section page 76 of Law of Succession Act. You have the book?
Yes, I do.
Yeah, can you have it there?
It's on my drive somewhere.
Okay, I have the physical copy. So at the alteration of wills, that is page 611 on page 76, eh? You're opening?
Yes, continue. I will catch up. Page
76. I don't know if the online copy is usually have the same page. Other alteration, such alteration of wills and cold seals.
Okay. Validity of wills. Alteration. Okay. Revocation.
By marriage, revocation by divorce. You can see?
Yes.
Before you start the revival of wills.
Yes. Alteration of wills and codicils.
Yes, the last paragraph. In Roseford Goods, you can see,
Yes.
And it was said that when an unattested alteration had been made after the execution of the will, the precise effects depends on whether the original wording is apparent or not apparent. The original wording will be apparent for the purpose if the original words can be deciphered by an expert through natural means. This means that the original words can be ascertained from the face of the will without physical interfering with the will. According to Lee Harmer's Estate 1943, where an attested alteration has been made and the words are apparent, the will is admitted to probate with the original wording, ignoring the alteration. Where an attested alteration has been made and the original words are not apart, the general is that probate to be granted with a blank space. So those are case law you can use,
Yes.
especially the second for this in the Harms estate. You can use that case law for here.
Yes.
Yes, because this question can be asked again in on Monday, the other Monday, when you're doing your exams.
Okay.
So we go to the next question. Of course, question 3. We are in question 3. Cheese versus Joe, that was the B. Section 20, it discusses the section 20, and as you had said. So we can go to the next question. Gabriel was diagnosed with COVID-19 coronavirus in February 2020. She was immediately rushed to the hospital and put on oxygen immediately. After a few days, she was sent to quarantine facility in the outskirts of the city. Having looked at media reports on the disease, she believed her days were numbered. She called her daughter Madonna and her son Maradona. Then, in the case of anything, all her assets should be divided equally between the two. She further told them that her fiancé Ronaldo would administer the estate since he was trustworthy and he knew everything about her property and finances. She told them that she intended to give him the commercial property maybe as a gift. She vowed that by gifting him the said plot, he would not neglect her children. He then called Ronaldo and told him that she was given him the said Mebro commercial plot as a gift, and then she would administer her estate and ensure her children got equal share of all the property and asset. She then told him to organize for a Zoom meeting between her two children, himself and herself, so that he could proclaim everything in presence of everyone. 2 days later, they had a Zoom meeting, and Gabriela emotionally proclaimed, "I am certain I will survive the disease. I am not certain I will survive this disease, and this is my wishes in that I pass on. All my possessions, including cash in bank, shares, plots, and real estate investments, shall be shared equally between the two children, Madonna and Maradona. Ronaldo shall be the administrator of my estate. I hereby appoint him as the executor of my wishes. I have given my commercial plot at Mebe to Ronaldo as a gift. I've also given him the Land Rover Defender as a gift since he's helped me buy it. She asked her daughter Madonna, who had a good handwriting, to put in writing to have each of them append this signature. This was done and dated 14th February 2020. Gabriela stayed at the quarantine facility and was discharged after 2 months. The doctor told her she was liberty to go home and continue her daily life as she had no longer had virus. Gabriela was finally reunited with her children and fiancé. In December 2020, while on Christmas vacation, realizing how fragile life was, Gabriela and Ronaldo decided to formalize their relationship. They set in the motion plans for traditional marriage ceremony. They set the date of the wedding as 22nd August 2021. Before the Ronaldo extended family was to visit Gabriela family for purpose of proving the traditional rights of dowry. In consultation with her family, the visit to her home was set for 15th April 2021. On 15th April 2021, when on her way to rural home for preparation, her car was involved in a tragic accident. She died on the spot. She left her son, who was still a minor of 17 years, and her daughter, who was 20 years, and had just been admitted to Ivy League University to study psychology. After funeral, Gabriela's elder father was keen on petitioning for grants of administration to enable him administer the estate. Ronaldo was of the view that the deceased husband, since they lived and cohabited together, had already planned the wedding. The children were also of the view that their mother wishes documented on 15th February 2020 should be applied as a will. With the help of case and statutory provision, give a legal opinion on the validity of gifts Gabriela gave to Ronaldo on 14th February 2020. Marianne?
So the gifts given to Ronaldo were in contemplation of death. So they are donatio mortis causa. And in considering the donatio mortis causa, we must see that they meet the requirements given in Section 31 of the Law of Succession Act and the cases of Kane versus Moon and Beaumont. So the gift has to be in contemplation of death. In this case, Gabriela thought she was going to die from COVID's pandemic. So yes, these were gifts in contemplation of death. That the donee predeceased the donor. In this case, Gabriela died before Ronaldo. So the gift that the donor must die as a result of the illness or imminent death. In this case, Gabriela actually survived her illness and died much later on of a car accident. So in this case, I feel like the gift would fail. That the subject matter of the gift was transferred to the donee. In this case, the gifts were the estate in the plot of land in Membley and a Range Rover. However, Gabriela failed to pass for instance, the deed of, she did not effect transfer of the Membley plot to Ronaldo. Neither did she give him the car keys or the logbook to the vehicle. So they failed. And then the subject matter of the gift. In this case, it was both movable and immovable property. And as we had covered in Kabute Ole someone, I forget the name, the court held that pursuant to Nordi LG versus Hedbury, that even land can be given as subject to donatio mortis causa. So the subject matter is not the reason why the donatio would fail. The donatio fails because there was no transfer of the subject matter to the donee, and that the donor did not die of the illness or imminent death initially imagined.
So that means the property would
the property would devolve back to the estate.
Yeah, you must complete. Yeah, you must complete that way. That is how you that's how we should. That's how you should finish. So you got that's well answered, and it was 4 marks. You see now this question was in October 2022. It's now in March 2023. That means the students did not answer it well, so it can also be repeated again in the exam that you are going to do. So it's a very key area. Assuming Ronaldo had gone ahead to petition for letters of administration stating he was the deceased husband, Madonna and Maradona approached you for advice after seeing it in the special gazette notice. Maradona has turned out 18 years, of course. They both worried he knocked them out of their mother since it did not include their names in the petition. Explain the proceedings you will need to file and the grounds thereof so as to protect the interest. Miriam?
So Maradona has just applied for petition for letters of administration. So after that application, there will be gazettement of the application. As such, Maradona and Madonna and Maradona should apply for objection to the proceedings under Section 68 of the Law of Succession Act. And then the grounds should be they're objecting because one, Maradona is not the party entitled to take out grants, because pursuant to Section 66, it should be a spouse, then a beneficiary, then
Ronaldo.
Yes, and Ronaldo is not her husband. They had planned the ceremony, but they had not gone through with it. She died before they married, so she's not the husband. Secondly, there's concealment of material facts, because he mentioned that they are beneficial heirs, in that Gabriela had left behind 2 children.
Yes. So you need a case law there, or an objection where children objected to the granting of grant for the person to nini. So you need also to know how to draw an objection. I'm suspecting this may come as a question. How to draw an objection. And on your screen, I'm projecting the objection to making of a grant. You can see it?
Yes.
So objection to making, from the heading, objection to making of a grant, general form. 2, you name the registry. Take notice that Maradona and Madonna hereby object to the making of grant or representation of the estate of the above Gabriela, who died. You put the date, and so the petition filed on. The interest of the said estate is that filed on the register, you put the date. The interest of the said Maradona and Madonna is that they are children of the deceased, and the grounds of his obstruction are as follows. Then you put the grounds that we have discussed, dated. This, you sign as the advocate for the objector there, and I think it's very, very important to know how to draft this thing. This document is online. If you type objection to making of a grant, you will see it. Because such kind of question of drawing a notice of objection have not been tested in the past, I'm suspecting it must come as a drafting question. And it's good to know how to draft. Are we together?
Yes, we're very together.
Yeah. So then next question. Explain whether Ronaldo is the husband of the deceased for purposes of succession.
Ronaldo, okay. Ronaldo, and first of all, there no marriage took place between Ronaldo and Gabriela, but there's the presumption of marriage under cohabitation given to us by the cases of Hortensia, Wanjiko Yawe, and the public trustee, and the recent case of Mary Nyaka,
yes.
given by the Supreme Court at the beginning of the year. So, for one to be a husband, one either has to be married, and the forms of marriage provided by the Marriage Act under Section 6, either a civil marriage, customary marriage, Hindu marriage, Christian marriage, or a civic marriage. And in this case, they had yet to formalize their customary marriage. As well, we cannot, the conditions given for presumption of marriage is that they have been living together for a period of time, that there are issues, children, that they portray themselves as husband and wife by reputation to the neighbors and everyone, that they both had capacity to enter this marriage, that they had the intention to enter marriage. In this case, however, they have been living together, but it has been clear that Ronaldo is the boyfriend of Gabriela, not the husband. As such, I do not, and they have no issues. They've only been living together for a short period of time, not sufficient enough, and they've not been carrying themselves as husband and wife in public. As such, I do not think the presumption of marriage arises. So, based on my analysis, Ronaldo is not a husband, as he's not legally married to Gabriela. Neither is their stay together sufficient for presumption of marriage to be assumed.
Very good. You have answered it. That case law in the Supreme Court, it's every time. Leave it now. That is old case law. The case law in the Supreme Court is now the law.
Yes.
It's MNK versus PMO. Is now the case on presumption of marriage, and it has 1, 2, 3, 4, 5, 6, 7, 8 parameters of presumption of marriage, which you need to know them in an exam, and you analyze them together with the question. Yes, together with the question. And I'm suspecting also, I'm suspecting this kind of question on presumption of marriage. My gut feelings tell me to come. It will come. I'm have a feeling that it will come. So you discuss this case law, the Supreme Court case law, know the citation and the 6 factors for presumption of marriage. Are we together?
Yes, we are very together.
So presuming now that Ronaldo is not the husband, who is supposed to take the grant?
Sorry, Mwalimu, I think I've lost you. You're breaking.
I'm saying.
Yes.
Now that the Ronaldo was not the husband to Gabriela, who is supposed to petition for grant?
The person who's supposed to petition for grants under the hierarchy is, of course, after the spouses, we have the children. After children, it's creditors, then public trustee, or vice versa?
No, it is parents. It is parents.
Oh, okay.
It is
other beneficial heirs.
Yes, parents, brothers in equal rank. Previously, you remember in benefiting or taking a grant, a husband, a man had a higher precedence than a woman or the mother. You know that. But
Yes.
there is that case law that nullifies those sections. You know it in Meru.
I think I have written it somewhere.
Go and look at it.
Okay.
It can also come as a question. That is leakage, as I'm telling you. It can tell you to discuss that.
Yes.
Go and look at it and discuss the findings of that case. It can come as 10 marks. It asks you what was the finding in this case and discuss.
Okay.
Very, very important. So this person, the people who are supposed to petition for grant here is the children, the two children jointly, because they have reached 18 years. Yeah, not the father, because as far as the hierarchy is concerned, the father of Gabriela has a lower hierarchy than the father. So we go to the next question. Question 5. We are moving very well today. Debra Apisana is a rich woman living in Nairobi. She owns blocks of apartments. Debbie suits within the Lavington Corporation of 15 units of residential and 2 large offices. Uses the 2 large offices and for official business. She had a good relationship with the tenants. She lives in Karen and has 2 grown sons, Peter and Maxwell, who also work in Nairobi. The sons rarely visited Debbie in her office and are known to the tenants. Rent was paid directly to Debbie in her office. 3 months ago, Debbie died in a road traffic accident. She died intestate. The tenants have not paid rents for the past 3 months, despite being given time to clear their arrears. They are adamant that Debbie never introduced the 2 sons to them, and they have no proof of their status. They have therefore refused to pay rent. Peter and Maxwell has come to you for legal advice. Advise them on the relevant grants they need to take out to enable them to take action against the tenants. Miriam, what do you think?
So of course, with regard to the rent, we have to be able to collect it and prevent waste. So there should be a limited grant for ad colligenda bona, but we should also be able to sue the tenants for the rent they have yet to pay. So I would do the, not pendelete, what is that one called? Am I forgetting?
Ad litem.
Ad litem, yes, thank you, ad litem. So that we can recover the rent they have not paid us, the arrears.
Yes.
Yes.
And you need a case law. We said yesterday this question is also repeated again. Question 6, October 2022. We dealt with it yesterday or on Thursday. So this means this question has not been done well by students. It has not been understood. So there is a possibility a question on limited grant would be asked. A case law on colligenda bono is there on question on the Q&A. You need one case law. It is there. Question 5, June 2021, there was a case law. And also you can be told to draft. We looked at the draft on Thursday. We don't need to repeat. You need also a case law on grant ad litem. Go and find. I told you as a case law. Find one where someone petition for grant ad litem for the exams. You see it has been repeated again, so it's good to have a case law and also know how to draft both applications. Yes, are we together?
Yes, we are.
Which B, if Peter and Maxwell were minors, what step would you take to ensure that legal action is taken against the tenants?
If they were minors,
Yes.
Against the tenants, the court would need to appoint 2 administrators to preserve and take care of the estate until the minors, of course, attain the age of majority.
Which section is that?
The one for continuing trust is section 41, but then appointment and I know the vestment of property is section 79. Appointment of administrators. Unless I check.
Okay, this Debbie did not have any known relatives, and these are children who are minor. That is the.
Then I think it's the public trustee.
Yes. Public trustee.
Yes.
So where there are no relatives, the question is asking you on public trustee. What do you know about public trustee? A very, very important question.
A public trustee is a person who comes in to administer the estate of someone who does not have, who there was no executor administrator appointed and no one has maybe like elected to do that position. It's governed, of course, by the Trustees Act. There's a procedure for protecting estates. For instance, if a person dies and no action has been taken, the local chief will serve a report on the public trustee and inform them like this person died, and the chief, in the meantime, before the public trustee can take over the matter, will be there to look after and preserve the property of the deceased. And then the public trustee can petition to take over the matter and preserve the estate of the trustees and distribute it accordingly to where the beneficiaries as they will deem fit. In some instances, the estate is very small, so the public trustee does not even need to issue a grant for the estate to be distributed.
What is
that's all I know about the public.
What is the threshold for petitioning?
Usually for the public trustee to become involved, either, for instance, if it's in testacy, the person is dead and the executors have renounced probate, or if it's in intestacy, or they've either renounced or they are unwilling to act, or in testacy, it could be a situation where no one has applied or obtained the grant for the letters of administration within the requisite 6 months. Yes. So the deceased himself actually appointed a public trustee to be the executor of their will.
Yes, you have tried, you have some knowledge on it. So a question on administration on public trustee was last tested in question 3A November 2015. So that was a very long time ago. And that's why they repeated it. I know the student did not do well in this question because it's usually not done well. So it may be repeated on those grounds. So neighbor to report to the police officer or administrative on the death, that is section 41A of Rules of Succession Act. The police officer or administrative officer, of course, chief, makes steps to protect the estate. That is section 46(2). The public trustee, upon receipt of the report, would under section 6 of the Public Trustee Act, make further inquiries as to the estate of the deceased. When the estate of the deceased gross value does not exceed 20,000, it does not need to apply. More than 20,000 and there is no person, he applies. After payment of all the fees, If they are non-beneficiaries, you give them, like here, the children. If there are no non-beneficiaries, the property go to the state. Section 56(1) is also very relevant of the Rules of Succession Act. No grant of representation shall be made to any person who is of minor or sound mind. So that was the starting point. Because these are minors, they cannot be given grant. Section 58. When there is a continuing trust arising, a public trustee can be given as a one person. It says, when a continuing trustees arise, no grant or representatives in respect of interstate shall be made to one person alone, except where that person is public trustee. That is section 58(1) of the Law of Succession Act. The public trustee can be given. So section 65 also is very, very important of the Law of Succession Act, where there is no executor, no residual legatee or representative, or if such person declines or is capable of acting, cannot be found, the person who are entitled to administration of the estate of disease, he may be died in test, the public or another have a beneficiary or creditor may arbiter to prove the will. So that is the section that gives the public trustee grounds to go and take the grant. Are we together?
Please repeat that. No, please repeat it. I missed it.
Section 65 of Rules of Succession Act is the one that gives the trustee power to go and take a grant. Sawa sawa?
Yes, asante sana.
So, you can also be asked how, of course, it's a petition, normal petition. A public trustee did go and look at it, and a case law where the public trustee was given the property in absence of known dependents of the estate. I think you can find a case law. I was trying to find, but time ended before this class could start. Are we together?
Yes, we are together.
This is a question that can be repeated. You have already seen two questions in October 2022 and was repeated in March. That was the question on objection, the question of collegiate abono. So I think this question can be repeated again based on the grounds that students were not able to do the question well. So it is very, very important someone be ready to answer it satisfactorily. Sawa sawa?
Yes.
So we go to the last question of the day. That is, Anne and Tony got married 5 years ago. Out of marriage, they were blessed with baby girl Camila. Shortly thereafter, they were serious of making wills and they visited their lawyer. They instructed him to prepare 2 mirror wills of each other, leaving everything to each other, and in that none survived the other. Then all was to devolve to their only daughter, Camila. The lawyer subsequently prepared the 2 wills. He called them to visit the chambers to prove and execute the will, but they were not available on appointed date. A few days later, Tony was killed in a suicide bombing incident. Apart from his wife Anne and daughter Camila, Tony was survived by his other brother Jack. After funeral, Anne was doing through his documents, found a duly executed will prepared by their lawyer dated 10 years ago. In his will, Tony bequeathed his estate to a charitable trust and appointed Jack as executor of the will. Anne, as a subsecretary, approached you for legal advice and advised her on validity otherwise of the will made 10 years ago.
So this question is testing again on revocation of wills, specifically the one provided for under Section 19 of the Succession Act that talks about involuntary revocation, by this one being by marriage. So the will that was done years ago, granting the property to a charity, was revoked by the marriage of Anne and Tony. So it's not in operation.
Yes.
That is what I would say.
Yes, that's the correct answer. This was 3 marks. If you can get, someone can get an English case law on this, it's very, very important. There are no cases, of course, such kind of scenarios cannot happen in Kenya, or it's rare for them to happen. So I think in English, it's good to get a case law on this for future purposes. This is the first time such a question was being asked. So I did not have a case law. I did not also have time to research. But when I upload this Q&A, after researching, I think I will have try to get a case law. Before we go to the next question, explain who would be entitled to take out grant and what type of grant should be applied for. Miriam?
So the type of grant that, sorry, explain who is entitled to take out grant and type. Okay, so the type of grant, as the previous will is the previous will is invalid. The current will, the mirror wills they had done, unfortunately, they had not been able to execute them. So they're also invalid. Mm-hmm. As such, the type of grant we applied for would be grant of letters of administration. And the person entitled to do this is Anne, as the wife of Tony. She can do this. And she'd be the preferred administrator, as she's also going to be the residuary legatee. So yes. Mm-hmm.
Another supplementary question there: what documents do you need for grant of letters of administration intestate?
We will petition the courts for the grant of letters of administration, and we will support our petition with a supporting affidavits. Then we can also we will also support our application with affidavits for justifying the proposed administrator, the guarantee of the surety, the justification for the proposed sureties.
Yes, and also affidavit of means, then death certificate. You can be able to draw the document.
Yes, it's a petition. The only thing that it differs for with the other ones is that, of course, now we don't have a will, and we have to do a schedule listing all the beneficiaries and the assets and liabilities of the deceased.
So it's very, very important to know how to draft a grant for letters of administration intestate. Or grant of probate. This question has not been tested recently on drafting of this document. So I'm suspecting that it might come based on the fact that it has not been tested recently. I'm suspecting this question, especially letters of administration with will, with intestate. I'm suspecting it will be asked as a way of as a question of drafting. Sawa sawa.
Yes, Walimu.
Our final question for the day. Anne is of the view that the intended will by Tony prepared by the lawyer is valid. She believes the same represent Tony's last wishes and she could have held. with help of statutory provision and case law, advise her on the validity of advice of written will prepared by their lawyer.
So the mirror wills were written wills, pursuant to Section 11 of the Law of Succession Act, and for them to be, for the wills to be valid, they must fulfill the mental, the capacity of the testator to write the will, the knowledge and approval of the contents of the will, and the physical requirements of the will. So, of course, and the husband, Tony, had the mental capacity to do the will, and he approved of the contents and knowledge of the will because he went to the advocate to do the wills. However, the will was warned of the formal requirements of the will. The will was written. However, the will was not executed as they did not find time to go and execute the wills. And the will was also not attested by two independent witnesses. There's also
there's also the
fact that even if it was okay, we can't really bring in Section 13. We can just say it was not properly attested. Yeah, pursuant to Section 13.
Attested, Section 11.
Oh, Section 11, sorry.
Section 11.
Oh, yes.
So, how a will should be drawn, signed by the testator and signed by two witnesses. Who sees the testator signing? We are not done in this question. That is what was testing. And you need a case law here. You need a case law either where the testator did not sign or where there were no witnesses who witnessed the will. One case will suffice for the question. And I think
I know. I had a question. In Madame Ruto's notes, she's written, I think, for the requirements, I think she's given Rebravda. But isn't that bad law now?
Say?
Rebravda.
What did the case law say?
I think it's on the physical requirements of the will, specifically, I think, on attestation. Because I think it was on attestation by, was it attestation by beneficiaries? And I think that case used to say that the whole will is invalid, instead of now where the act says it's just that bequest that is invalid. That's why it was bad law.
Yes.
So I don't have any other case law. But her notes still indicate that case, so I don't know.
Yeah, that is bad law. It needs to be, you know, Madam Ruto have been there for so many years. And they usually don't amend those case law.
Oh, okay.
That's why even the Q&A, I say it is a time when I did the research and I dedicate the date there. And if I get a new better answer, I change. Are you getting?
Okay.
For example, you cannot talk about the Yahweh, hostation Yahweh on presumption of marriage. The current, the case law that is there now, it is the Supreme Court case, petition 9 of 2021. Which it in fact added some factors. There are 7. Are you together?
Yes.
So it's very, very good to have current law. In fact, I usually when I am doing my Q&A, I usually like to use the case law that have been delivered recently, even if I will not go back, and if there was an answer I had answered earlier and I used the case law, I usually don't like to use that case law again. I usually look for the newest case law because that's the law keeps on changing.
Yes.
And there are better arguments. Of course, you look at the hierarchy of the courts. Also, it's very, very important. Supreme Court decision precede the other lower courts. Their decisions Also, there are amendments to the law. Also, there are courts declare section invalid. So, in fact, that case law I've told you that was decided in May, go and look at it. It's very, very important.
Yes.
Because for probate, go and look at it. Very, very important.